Unless until you cannot wait till Monday, don't mention any matter. Mention on Monday.
My lord, may I permitted to mention in the compelling situation, this matter was fixed by the Honorable Justice Subra Ghosh on 5th, but matter did not appear. Urgency is that,
Very well. What is the urgency?
my lord, urgency is that, my lord, petitioner get some amount from the Pradhan Mantri Awas Yojana scheme. The private respondent restrained to construct the house, my lord. My lord, I informed the police.
You cannot wait till Monday.
Yes,
to mention the matter. Mention on Monday.
Leave, lord.
On indulgence.
Please mention on Monday. Because I disallowed mentioning yesterday also. Don't embarrass this court.
Your Lordship, may I have your kind leave to mention there is extreme urgency in the
Yes.
matter. WPA 4735, Your Lordship, Honorable Justice Shubhra Ghosh had fixed this matter on the next date on 12th March. Challenging this order, I had filed an appeal. Honorable Chief Justice has directed the matter to be heard on urgent basis, Your Lordship. I can't produce the order of the same because it was just heard yesterday. The same has...
Very well. You bring the order on Monday, then I will consider it.
Your Lordship.
Yes.
Milord, only one indication, Milord. This matter, Milord, was made returnable today, Milord, by my Lord Justice Shubhra Ghosh.
Mention on Monday.
I am deeply aware.
Yes. Call the list.
My lord, I am appealing for the alleged contents.
This is from combined list, huh?
Yes.
794.
My last occasion they met.
Pending. You. Yes, any order?
Yes, it was heard by the division bench, but it got adjourned as the writ petitioners, nobody appeared on their behalf. Recording that one order has been passed and it has been fixed on 11th March.
My lord, may I permit? And one that
Why
they
it did not appear before the honorable
they
division
did
bench?
not serve notice to us to
Upon
appear.
notice it was moved.
No, my lord, there is no instruction on that, my lord.
Serve Karachi.
There is no such notice. I am praying for adjournment on a week that
May I hand up the division bench's order?
So let it be in the matter is running in the list of the honorable division bench.
It was adjourned and fixed on 11th March. This is the order.
Oh,
Next monthly list, let the matter appear. Issue. Matter is taken, contempt application is taken up for consideration when Dr. Patro, learned advocate representing alleged contemnor, alleged contemnors.
okay.
Has placed before this court order of the honorable division bench dated 23rd February 2026, passed on an intra-court appeal being FMA 1347 of 2024, and same is taken on record. Stop. From it appears that honorable division bench video order dated 23rd February 2026 fixed the appeal and application for hearing on 11th March 2026. Stop. Next paragraph. In view of pendency of the appeal, let the matter, let the contempt application appear under the same heading in the monthly combined list of April 2026.
Deeply obliged.
Next.
I'm for the petitioner, my lord. After direction, I serve the copy, refuse the contempt. Serve refuse service, man.
Service is complete.
Refuse. Serve. Page 27, my lord, order. I communicate the order, my lord, page 30, and receive, my lord, page 35.
Issue. Affidavit of service filed on behalf of the applicant is taken on record. It is submitted by the learned advocate representing the applicant that notice which was served upon the alleged contemner was refused. Stop. It transfers from the affidavit of service that the envelope containing notice and copy of the contempt it transfers from the affidavit of service that envelope was refused to be accepted by the alleged contemner on 13th February 2026. Stop. Next paragraph. Learned advocate for the applicant is directed to serve a notice enclosing copy of this contempt application and order passed today upon the learned advocate who represented teacher in charge of Rothipur Baroda Banipit within bracket HS close bracket Paschim Medinipur by March 11th, 2026 and file further affidavit of service on the next date. List the contempt application on 26th now. By কত বললাম by 11th March. List the contempt application on 27th March 2026 in the supplementary list.
Well, I saw Mr. Sarwajan, but
That you, what I will tell you, who represented, there is an order, respondent number 8 was represented by learned advocate. At the time of call, no one appears for the applicant. And no accommodation is paid for. Stop. In order to grant one more chance to the applicant, hearing of this contempt applications is adjourned. List the contempt application under the same heading in the monthly combined list of April 2026. Stop. However, it is made clear that on the next date, if applicant goes unrepresented, consequential order shall be passed. Next.
And for the petition. Order on 9 January 2025.
Overdrawn amount কত ছিল?
হ্যাঁ কিন্তু এটা কি দিতে বলেছে রিকভারি
হ্যাঁ এই তো রিকভারি যেটা আছে এইটা তো
আমার কাছে আমি এক্ষুনি আজকে মেসেজ পেয়েছি
পেন্ডিং রাখ আমি দিয়ে দিচ্ছি এই তো 10 লাখ
convention in the original PPO. রিকভারি লেখা আছে
রিকভারি মানে যেটা তোমার ছিল রিকভারি যেটা দেওয়া ছিল
এইটাই পেমেন্ট করতে অর্ডার দিয়েছে না কারেন্ট
আরে এই তো কালকে পাঁচ কালকে Yes.
Order has been passed, Lord's recovery amount.
Revised pension payment order has finished.
Revised payment.
yesterday has been passed.
So it has been complied with.
Payment has
You will get the payment.
Go to the treasury office.
Have you seen the revised pension payment order? So that this 10 lakh 6,872 was
Last recovery, Lord, 10,000.
where
Last figure, Lord, 1,006,872.
middle portion
Recovery penny, 1,006.
yes
Lord.
10 lakh 6,872.
but let it be placed in the next month list. Otherwise I have not yet received the money
Issue.
So go there to treasury.
এখনো দেয়নি
আরে দিয়ে দেবে না হলে তো এমন একটা কথা বলি
Mr. Bhaskar Prasad Boisho, learned additional government tutor, appears on behalf of the alleged contemner.
নেই ওই জন্য তো রেখেছি
You are representing both the contemners. Appears on behalf of
No, no, only for the director of pension and provident fund.
appears on behalf of alleged contemner number 1 and has submitted that the order is complied with by issuing and has submitted that in terms of the order dated 9 January 2026 passed on this contempt application, a revised pension payment order was issued on 5th March 2026, thereby sanctioning rupees 1006872.00 in favor of the petitioner. Stop. Copy of the revised pension payment order dated 5th March 2026 is placed before this court and same is taken on record. Next paragraph. In view of issuance of revised pension payment order dated 5th March 2026, it appears order passed by this court on 12th March 2025 on the connected writ petition is complied with. Stop. Next paragraph. Concerned state respondents are directed to release the amount in terms of the revised pension payment order dated 5th March 2026 by 4 weeks from date. Stop. Next paragraph. Contempt application is disposed of and contempt proceeding stands dropped. Next.
Your Lordship, I am for the petitioner. I am led by Mr. Sudipto Dasgupta, Your Lordship. He is engaged in a matter before the courtroom number 24, Your Lordship. Kindly make it not today.
We will be using an affidavit in the matter.
Well, let Mr. Dasgupta comes. Let it be considered. Let it retain its position in the command list. Not today. Okay.
Item number 799.
But I am for the petitioner, my lord. My person to my lord's direction, my lord. I have effected service upon the alleged contemptor. This is my affidavit of service. But this contempt application is arising out of the order passed by my lord dated 23rd April 2025, my lord, which is appearing at page 18, my lord, whereby my lord was pleased to direct the board, my lord, to take a decision on the with regard to the fate of the suspension order dated 18 March 2025 issued against the petitioner within 6 weeks from the date of communication of that order. But till date, my lord, nothing has been done, man. As a result of
problem is when the order was passed, board was not represented. Now, who appears? Mr.
Nadim Suleiman.
Now, you serve notice upon Mr. Suleiman. File your affidavit of service. Issue. Affidavit of service filed on behalf of the applicant is taken on record. Next paragraph. In spite of service of notice, alleged contemptor. In spite of service of notice, President West Bengal Board of Madrasa Education being alleged contemptor is not represented today. Stop. Learned advocate for the applicant is directed to serve notice upon Mr. Nadim Suleiman, learned advocate, who usually represents West Bengal Board of Madrasa Education, enclosing copy of this order and the copy of the contempt application by February 11th, by 11th March 2026. Stop. List the contempt application under the same heading on in the supplementary list on 27th March 2026.
I am applying for the contempt, Your Lordship. Your Lordship directed to file a report, Your Lordship.
I am appearing on behalf of the petitioner, Lordship. I am led by Mr. Shoboshachi Chatterjee. He is engaged in some other court, so I am praying for short passover.
Okay. Why contempt?
My lord,
Within 6 months,
6 months that was.
proceeding could not be concluded. Now,
my
what is the
challenge-
stand? দেখি affidavit টা দাও।
Now, my lord, challenging the,
এখানে দাও, ওরম ভাবে দিলে হাত পাচ্ছি না তো।
well, after the, we received the final inquiry report, board has issued a second show cause for asking to reply why compulsory retirement should not be given. So, my lord, he has replied and he has said, I have not seen that inquiry, he was not called for inquiry. So, my lord, we have asked the inquiry officer to give the details whether in help. On the other hand, lordship, the petitioner has filed another writ petition challenging the second show cause notice. Very recently, my lord.
Issue. On behalf of alleged contemners, affidavit of compliance affirmed on 5th March 2026 is filed today and same is taken on record. Next paragraph. On behalf of the applicant, accommodation is paid for on the ground of learned activity. Stop. Hearing of this contempt application is adjourned. List the contempt application under the same heading in the monthly combined list of April 2026. Add a line. However, it is made clear that pendency of this contempt application shall not preclude the concerned authority of West Bengal Board of Secondary Education to conclude disciplinary proceeding which is initiated against the petitioner.
Number 801.
My lord, with your lordship leave, my lord, I want to appear, my lord, virtually. My lord, with your lordship leave, my lord, I want to appear virtually in this contempt application, my lord. My lord, am I audible, my lord?
Yes, affidavit of.
Yes, my lord, there is only one difficulty, my lord. I have got it affirmed, but my lord, my clerk, my lord, he is coming to the court. I have affirmed, I have also served. Lordship,
All right.
kindly have a look. In course of the day, I shall file it, my lord.
We are for the alleged contempt now.
The director of pension and
Whether
provision.
the order has been complied with.
No, let's complied with, but some part of my learned friend to submit before the court. Complied with, lots of PP has been issued, lots only for the interest part. That is the lots due to the matter is pending before the division bench. So I am not complied, lots of that.
Division bench, আমার মামলায় তার সঙ্গে আমার মনে হয় কি সম্পর্ক?
My lord,
June.
my lord, am I audible, my lord? কিছুই হচ্ছে না। ভিডিওটা অনই করতে ইচ্ছে না। You cannot start the video because it is disabled by the host. আমি তো অন্য মামলাগুলোতে আমি করবো ঠিকই কিছু ওইদিকে মামলা করছে কিছু তো আছে আমার তো অনেক হচ্ছে না ভিডিওটা অন হচ্ছে না
Now you have preferred appeal against the judgment dated 2nd January 2024.
Dear Lordship, first writ petition was heard Justice Roy. Thereafter,
Yes.
Lordship directed to Lordship comply the Lordship's order without filing any contempt. Here, Lordship, pension payment order has been issued only for interest part. So lots of writ petition was heard before Justice Mantha. Lordship directed to pay the Lordship interest. That order has been complied before the prefer an appeal before the division bench.
No, but here Justice with the judgment dated 2nd January 2024, there is a direction.
Same identical matter.
Maybe
When
if in this against this order come to page 26 of the contempt application.
26 Lordship, I've seen Lordship.
While sanctioning the necessary pension in terms of the said notification dated June 13, 2014, respondent number 6 shall calculate the entire amount together with interest at the rate of 8% per annum to be paid to the petitioner on and from 2nd September 2014 as the petitioner had returned the money on September 1, 2014. Now, if against this order, have you preferred appeal?
No, Lordship. I am coming, Lordship. Here, Lordship, only for the either comply the Justice Anuruddha order. Only for part of along.
Yes, that interest, this court also directed, since the
Lordship,
coordinate bench directed, it is to be paid.
But this identical matter, one the lots of matter was heard, identical matter heard before Justice Mantha.
If identical matter is heard and if it is interfered with or the order is stayed, in that event also contempt lies, because you have not preferred an appeal against this judgment.
Thereafter, Lordship, prefer an appeal division bench. Matter was heard in revision bench.
Identical matter, not this matter. So that will not.
Lordship say, Lordship, here that thereafter division bench, if any problem has been arise by the trial court, only Lordship, the matter is pending before the division bench, say the requested by the trial court. If the Lordship adjourn the matter, Lordship, I am division bench, let the matter heard by the division bench. If the
how this is related to another matter which is pending before the division
matter,
bench?
if the Lordship, I have complied the Lordship's order, my total Lordship, my division bench order infectious. Lordship.
Why?
Why, Lordship, if they comply the same identical, comply the Lordship.
What identical matter?
Same
Because
interest.
by this order only one writ petition was disposed of.
Dispose of Lordship, if we let the matter be adjourned for 2 weeks. In the meantime, Lordship, matter is mentioned before the division bench, let the division bench matter over heard. Otherwise, I comply the Lordship's order. Let the matter over. I mentioned before that here that the division bench not sitting on the 2 weeks or 1 week's Lordship. So, Lordship, I am requested, let the matter be adjourned. The matter I mentioned before it, Lordship. Their Lordship.
You are required to prefer appeal against this judgment.
No,
if you are not preferred appeal, then you have to comply the order passed by the coordinate bench. There is no other option left.
But Lordship, if may adjourn, Lordship, I will not succeed, Lordship, then I'll comply the Lordship's order.
If you succeed in that appeal, how that will help you in this matter?
Help me, when the Lordship interest part, same Lordship interest part, the lots of the Justice Mantha pays that lots of petitioner file same interest.
That is in connection with switching over from CPF to GPF matter.
CPF
to GPF matter, and their court it was directed that yes, when on switching over, pension payment order is issued. In that event, on refund of the benefits which are paid under contributory provident fund scheme, In that event, the pension which is to be released from the date following the date of refund shall carry interest.
But Lordship,
But that it is not that case.
but Lordship, larger bench not pass the any interest part. Larger bench justice.
But is it a similar issue?
Lordship, larger bench not pass the interest part. Larger bench only for the Lordship money, calculate the money and deposit the DI. Larger bench not pass the any order of the interest.
Just a minute.
Lordship. That the employee expressed their which was recording as under they did not claim interest in the area of case. So hence this interest was not allowed.
Why করছেন? করেছে করেছে
ইন্টারেস্ট যেখানে আমি তোকে বের করলাম এটা claim interest on the area of the area to have. And the area along with the interest, they did not claim interest on the area. Area alone. এর উপরে কোনো ইন্টারেস্ট পাবো এটাকে আপনি একটা কারণ করে সবাই ডিপার্টমেন্ট
Here the issue is different. In 1985, applicant first exercised option.
But here lordship
and which was taken into consideration and the state respondents objected. As a result whereof, in spite of submitting option in terms of June 2014 notification, benefit was not extended and there was a delay.
But lordship here lords all have
In that event, court considering that 1985 in 1985 filing of option should not be an impediment in extending the benefit under the notification dated June 2014 in terms of the special bench judgment of Obhijit Gui. So if that is so, this issue is completely different from other matters.
Here, no lordship. Here lordship, I am coming lordship. Here lordship. Here lordship, I am lordship.
And moreover, you have not preferred appeal against this judgment.
Contempt
Deep
is
leverage law.
for scope the argument the matter. But here lordship, I have only 2 or 3 points. Better lordship, here lordship, which are interest factor. Here lordship, the directed lordship justice, after receiving the fresh pension payment order from the office of the respondent number 4, the jurisdictional treasury officer Hooghly shall immediately pay the petitioner all area along with interest. Justice Roy passed the order. But the larger bench, Lordship, division bench passed the order. Lordship, here it is the noteworthy that the employee expressed their willingness to refund, which was recorded in paragraph 7. They did not claim interest on the area of pension. But Lordship, I am not arguing the matter due to the contempt proceeding, Lordship. If the Lordship passed the order, I am only simply adjourn the matter 2 weeks, Lordship. In the meantime, I success the division bench. Otherwise, the matter will not held, then I will, Lordship.
That is the appeal in group, in batch of matters.
Batch of lots of.
Where, but the issue in this
Same.
petition is
Same
different.
No, Lordship.
1985 exercise of option by the
Same issue.
candidate is not known.
No, Lordship. Same issue. The CPF of 1985.
Well, next monthly list you have received pension. In the meantime, only interest part on similar issue appeal is pending.
My lord, only one thing about the subject should leave.
By Mr. Roy, my lord.
The applicant.
My lord, with your lordship, my lord, your lordship has rightly pointed out, my lord, that between the parties, it's a binding precedent between the parties. What your lordship has said, my lord. But then, my lord, they had to comply.
It is a case of payment of interest, but you have you are receiving pension now.
That's true, my lord. That's true.
The order passed by this court.
Absolutely.
So interest part is withheld. So let them come back.
Absolutely.
The issue is pending before the division bench in connection with other matters.
My lord, subject should leave it whether, my lord, that
matter is heard in presence of the learned advocates representing the applicant and alleged contempt. You are representing which contempt now?
Director pension 3, Lordship.
So the affidavit of service has come, my lord.
File your affidavit of service. In the applicant and alleged contender number 3. Upore দিয়ে দাও, affidavit of service filed on behalf of the applicant is taken on record. Stop. It appears from the submissions made on behalf of the parties that petitioner is in receipt of monthly pension. Stop. Issue needs to be decided. কেটে দাও. It is next paragraph. It is submitted by the learned advocate representing the applicant that till date interest has not been released in her favor in spite of the order passed by this court on 30th June 2025. And judgment dated 2nd June 2024 delivered by and order dated 2nd January 2024 of a coordinate bench. Next paragraph. Mr. Boisho, learned additional government pleader representing respondent number representing alleged contender number 3 has prayed for accommodation. Stop. Hearing of this contempt application stands adjourned. List the contempt application under the same heading for further consideration in the monthly combined list of May 2026.
Liberty to pension.
Next.
Liberty to mention in case it is disposed of earlier.
No, let it come up. Already a major part of this order is complied with. It is only question of payment of interest. You wait for some time.
Obliged, my lord.
Obliged, my lord.
Made your lordship, I am for the petitioners, my lord. Issued affidavit of service, I have served. My lord, e-pension order had been issued yesterday. Yes.
Then it is complied with.
মানে
But it is also specifically directed in paragraph 8 that the state respondents are directed to release literal dues. That has not been done. Only pension payment order was issued
Retirement due, Lord.
issued on 5th of March 2026. So where is the payment?
Lord, sir, I am the auditor. Lord.
So whether let it appear. I record that the pension payment order has been issued, but payment needs to be made in favor of the petition. Issue. Affidavit of service filed on behalf of the applicant is taken on record. Stop. Next paragraph. Mr. Boisho, learned additional government pleader, representing alleged container number 1, has submitted that pension payment order was issued on 5th March 2026 and copy of the same is placed before this court, which is taken on record. Stop. However, next paragraph. Learned advocate representing the petitioner submits till date. Payment has not been made pursuant to the pension payment. Now, based on pension payment order dated 5th March 2026. Stop. Concerned state respondents being alleged whether the treasury of yes. Alleged container numbers 2, 3 and 4 are directed to release retirement dues including pension to the petitioner in terms of pension payment order dated 5th March 2026
But after completion of the formalities, Lord.
by fortnight from date. Stop. List the matter under the same heading in the monthly combined list of April 2026.
The formality is there.
What formalities in contempt? I have already directed.
Aadhaar card.
Yes, I have already directed that.
My lord,
But if the Aadhaar card is not submitted, how it's
Nothing.
possible to release the amount?
my lord, the DI,
Who will believe that he will not submit Aadhaar card for receiving
Well, Lord,
pension?
again, I am come before his lordship.
Uh-huh.
There's a
well,
Aadhaar
the
card is not-
contempt number 2, my lord, the
Let them
contempt,
come and say that petitioner did not
No, no,
cooperate.
if the lordship formality has to be complete,
my
I
lord, the
am not.
contempt number 2, retired. Now you want income has come there.
Oh,
Permitted.
দেখি দাও তো।
The my lord. They return back, the left.
Leave is granted to the learned advocate representing the applicant to amend the cost title and add present incumbent as additional alleged contemner in course of this deed.
My lord.
Stop. দাও. Stop. Next paragraph. After amendment is made, learned advocate for the applicant is directed to serve notice, including amended contempt application and order passed today upon the additional alleged contemner by fortnight from date and file a further affidavit of compliance on the next date. Next.
My
Item number 803.
I am for the alleged container. Pursuant to your lordship's direction dated, my lord, 13th of February 2026, my lord, I have served a copy of the application upon the contemner respondents.
MSD. Yes, sir. Yes.
Lordship, an appeal has been preferred, Lordship. It was heard on the last week, Lordship, and it is fixed on Monday. Section 5 application was there, it was allowed, and it is fixed on Monday.
No stay was granted, my lord.
No, the stay application is fixed on Monday.
On Monday, Lordship.
Issue. That is not required because stay application is not disposed of.
Yes, Lordship.
Then why you are not submitting this?
My lord,
You should have submitted at the threshold.
my lord, since my learned friend
Lordship was going
stated
So
that
far.
he will submit.
I am reading the judgment, my judgment, 2 or 3 paragraphs. It was not necessary today since the appeal is pending. It is submitted by the learned advocates representing the parties that an intra-court appeal is preferred against the judgment dated 13 November 2025
May I give the number?
along with stay application, and same is fixed for consideration on 11th March.
On 9th.
On 9th
Monday.
March
9th March.
2026. Stop. Next paragraph. In view of pendency of the appeal, hearing of this contempt application is adjourned. In view of pendency of the appeal, hearing of this contempt application is adjourned. List the contempt application under the same heading in the monthly combined list of May 2026.
Great.
Item number 804.
On behalf of the petitioner, my lord, this is first time contempt, my lord. Non-compliance of the order dated 18 August 2025, my lord, page number 171.
Yes.
171. 171. Paragraph number 5, my lord. Directing the Commissioner of School Education being appellate authority to dispose of the appeal preferred by the petitioner by 8 weeks, my lord.
So appeal is not disposed of.
No, my lord. Appeal is
Issue.
pending.
Learned advocate representing the applicant alleges violation of the order dated 18th August 2025. Stop. Learned advocate for the applicant is directed to serve notice enclosing copy of the contempt application and order passed today upon the alleged contemptor by fortnight from date and file affidavit of service on the next date. Stop. List the matter under the same heading in the monthly combined list of April 2026.
Number 805. That I am for the petition. 20 order dated 22nd September 2020.
Fresh contempt. New contempt.
New contempt. 22nd September 2025. This order ultimately challenged before the Honorable Division Bench. Honorable Division Bench upholds my lord's order. So this order is now remains.
So dues have not been cleared.
Even my lord, pension headmaster is not ready to forward the pension file. Client is repeatedly requesting forward the same. He is playing such.
So headmaster is the only contempt.
Only contempt. DI is ready to disburse the amount.
Issue. Learned advocate representing the applicant alleges violation of the order dated 22nd September 2025. Stop. Next paragraph. Learned advocate for the applicant is directed to serve notice upon the alleged contemner. Serve notice upon the alleged contemner enclosing copy of the contempt application and the order passed today by fortnight from date and file affidavit of service on the next date. List the matter under the same heading in the monthly combined list of April 2026. এটা কি হিয়ারিং কন্টেম্পট হিয়ারিং ম্যাটার? তো সেটা এটা বলে দিলে না কেন? এটা আজকে আমি এটা রিলিজ করে দিতাম। হ্যাঁ, আরে আমি তো জানি না যেটা কম্বাইন্ড লিস্টে কালকে ধরার মতো পরিস্থিতি হবে, বললেও পারছি, তাহলে আমি এটাকে রিলিজ করে দিতাম। কেন অন্য ডিটারমিনেশন যেখানে আছে সেখানে এটা যাবে, তাহলে ধরে রাখলে তো মুশকিল, পরের দিন এটা ইন্ডিকেট করে দেবে শুক্রবার।
Item number 1 from daily list.
Lordship, I am for the petitioner, Lordship. Lordship, I am for the.
I am for the state, Lordship.
Lordship, affidavit service, Lordship.
Where is the decree dated 27 November 2025?
Lordship, it's at page 20, annex P1.
So this court will evict the defendant.
Lordship, I am here for regarding inaction on the part of police at Pelur police station. The seal belly went over there. He was unable to take possession in spite of deposit of police.
Take this issue before the civil court.
The title
and get the execution of the decree.
They already filed. Execution already filed.
What this court, read court will do?
I am here only for inaction on the part of police authorities. Police authorities simply going and coming back in spite of deposit of police fee. Police cost also, Lordship.
Who is for the state?
I am for the state, my lord.
Where is the report?
Lordship, I have to obtain the instruction, Lordship.
It's not an executing court
No,
for execution of decree.
not execution, only
Passed by the civil
lordship,
court.
only.
My lordship, I am
Police is not acting as per the direction of the learned court be lordship. Police simply going in connivance with
Have you initiated an execution proceeding?
yes, your lordship.
So then take this issue before the executing court. That this is happening. Why the writ court will exercise its extraordinary jurisdiction?
No, I'm only here because on the inaction, the police is simply going and coming back in spite of deposit police cost also, lordship. As per court direction, petitioner deposit the police cost also.
My lordship, I am representing
Defendant.
4 and 5. So actually, there is alternative remedy at first.
Yes.
They have an alternative remedy in the civil court. Apart from that, what they're doing, just kindly come what their prayer.
Why you are not leaving the premises in spite of the decree being passed by the civil court?
Actually, their claim is 215 square feet of land. The decree was passed 3 kattha. In the plaint, their schedule was 215.
250
square feet only. So the itself decree, there was some anomalies. Again, the decree was passed. Again, Puro Mullik, son of Banta Dome.
The chapter has gone, lordship.
In the very first day, I said that I am not the son of Banta Dome. Though I am a Buro Mullik, but my father is a Posu Mullik. When I filed the written statement,
So
I said
according to you are not the defendant. Yes, you have filed the written statement. Just now you have stated.
I filed over there. I filed over there. In doc, when I gave the evidence, I also told that. But they dragged me. Okay, fine. We lose the case. But what was their schedule in prayer? Only 215 square feet. And decree was passed 3 kattha. They could show the decree. Decree is with me. So there is so many things. There is a human right violation.
Actually, they preferred an appeal.
We will file the response.
Lord, they prefer an appeal. They have lost.
Very well. Decree is still standing. It has not been interfered with. Even then, for execution, writ court will not pass an
Lordship, I am not praying for
execution of decree.
I am not praying execution. I only the inaction on the police is simply going.
Affidavit of service filed on behalf of the petitioner is taken on record. Stop. Learned advocate representing the petitioner has submitted in reference to a final order dated 29 June 2010 passed by
First civil dismissal.
a civil court.
First civil judge
Junior
division
at Howrah.
Passed by a civil court that in spite of initiating execution proceeding in accordance with law, concerned police authorities are not taking necessary steps to evict the defendant. As per the said order of the civil court dated 29 June 2010. So, prayer is made. Direction for issuance of mandamus directing police authorities to facilitate eviction of the defendants based on order of the civil court dated 29 June 2010. Next paragraph. Prayer of the petitioner is resisted by the learned advocates representing the state respondents
4 and 5, Lordship.
And respondent numbers 4 and 5. Stop. It is submitted by the learned advocate representing respondent numbers 4 and 5. that the scheduled property in connection with the suit is different, and an attempt has been made on the part of the petitioner being plaintiff in the suit to get the private respondents evicted from the part of the property which is not within the schedule of the plaintiff. Next paragraph. Be that as it may, it appears from the respective submissions made on behalf of the parties that petitioner by filing this writ petition, comma, inter alia, comma, has prayed for direction upon the concerned police authorities, which would facilitate the execution process, which will facilitate the eviction of the private respondents. Private respondents based on order dated 29 June 2010 passed by the civil court. Stop. Next paragraph. The issue involved in this writ petition is civil in nature, for which petitioner is required to take necessary steps in accordance with law. Writ court ought not interfere. Writ court should restrain itself in passing direction upon the concerned police authorities for expediting the execution of the decree. Stop. In view of aforesaid, this court is not inclined to interfere with the writ petition. Stop. Same stands dismissed. Interfere with the writ petition and same stands dismissed. However, this order shall not preclude the petitioner to take steps in accordance with law. If order dated 29 June 2010 passed by the civil court still subsists. Next.
Takes up this matter, I would like to make a unjust request. I have not received.
Yes, you are appearing for the state.
Yes, I have not received the instruction. So kindly takes it up on the Monday, Miller.
Not today. Not today.
My lord,
I have heard the state council report has said.
state appeared, but private party, some private party, 7, 8, 9. But one private party has come to me, my lord, to my chamber. They have no objection for anything of my land. The land is, my lord, it's 5 decimal land was granted parta in favor of the petitioner, my lord. And the
what police authority will do?
Police authority will earlier move this application, my lord, here, my lord. The order passed, there is nothing, any disturbance, but petitioner said that until and boundary wall, they can every time, my lord, to encroach the land. So petitioner made application before the police authority for grant of police help for
police help for what?
We will stand, my lord, or I will construct the boundary wall. Only 5 decimal land granted parta to the window for residential purpose.
Whether the private respondents are objecting.
Private respondents, there is nothing. One private minister came to my chamber.
Very well, he came to your chamber. But what is the representation on behalf of private respondents?
My lordship, the Kindly come to page
Where is the
Page-
represent, whether the service
Hey,
upon the private respondent is complete, Mr. Manna?
Yes.
Service whether service upon private respondent is complete.
No service will pay for it.
Yes.
If necessary, I will serve the.
If necessary. What does it mean?
So
Then withdraw the writ petition, and if private respondent has no objection, then you construct the boundary wall.
No, what police.
But no order from this court that you construct the boundary wall. Police will render assistance.
Several order was passed.
Maybe
police-
several orders are passed, but court is
not our case, but another case.
This court is not concurring with those orders.
Otherwise, I cannot save my property.
One private respondent has come to your chamber. Another two private respondents come to your chamber in
they are not coming.
Sunday. So matter will be resolved out of court, and you will merrily construct the boundary wall. Who prevents you?
What report submitted?
No, I will not see the report at this stage.
So kindly give the 10 days time, my lord. I will serve.
Let them serve upon the private respondent and come back.
Lordship.
You keep the report with you.
Okay,
And let me consider what is the stand of the private respondent if private respondents are represented on the next
My
day.
lord, sir.
Issue. Learned advocate representing the petitioner has prayed for accommodation to serve notice upon respondent numbers 7, 8, and 9.
7, 8, 9.
Let the notice be served. A notice be served upon non-appearing respondents by 10 days from date, and affidavit of service be filed on the next date. Next paragraph, state respondents are represented by learned advocates. Stop. Next paragraph, hearing of this matter stands adjourned. List the matter under the same heading for further consideration on March 24th, 2026.
24th, lordship. One matter, similar matter.
Will let it be called on, Mr. Manna. Then I will not out of time.
matter হয় না ওরকম করে।
Because other side
But-
may be there. Yes, who is for the petitioner?
But I beg to appear on behalf of the state.
Ashish Satra.
My lord,
Yes.
my lord, I am praying for short password, my lord.
Why?
Just 15 minutes. My client is engaged, Mr. Amitabh Ghosh, he is engaged in code number 25. My lord, just 15
Have you obtained any instruction?
Yes, yes.
Well, not today.
As your lordship.
Much.
Madam, for the petitioner, before going into the matter, my lord, one bona fide mistake occurred, my lord. I have solved the respondent number 2 twice, but has not been solved the respondent number 9.
9.
9. my
Private
lord.
respondent.
One of
I
the
am going to
private
respond for
respondent.
9.
My lord, the affidavit of service. My lord, the matter is regarding the civil dispute. What happened, my lord? I am the owner and occupier. We are the owner and occupier in respect of some properties, my lord. There was an agreement for sale in the year of 2010 in between the petitioners and the respondent number 10. My lord, they will purchase the whole of the property from us. That was the sum and substance of
Representing respondent number 10, 11. 10, 11.
Now, my lord, based upon the agreement for sale, alleging the private respondent number 9, alleging the authorized by the private respondent number 10, my lord, purchase some of the properties, but not the total properties.
Who purchased?
Respondent number 9 and respondent number 11.
9
Purchase-
and 11 purchased some
Some of the properties they are in possession in respect of their properties, which they have purchased by virtue of deed of sale. My lord, in respect of the rest of the properties, we are in possession and we are conducting the business from that property, my lord. Now, my lord, in respect of a civil dispute, my lord, they are asking for a, my lord, ingress and right of ingress and egress through our property where we are in possession, my lord. They have filed a title suit before the learned trial court below. My lord, order of injunction was granted by the learned trial court below, my lord. After that, I appeared before the trial court below. I am contesting the case, my lord. There is no order of, my lord,
contempt, there is no application for contempt under Order 39 Rule 2A that we are not obliging the order of injunction. Neither, my lord, any application for police help was filed by the respondent number 9, 10, and 11 before the learned trial court below. What happened, my lord? There was an order passed under section 151 by the learned trial court below. Kindly come to the order once. It is in page number 156 of my writ petition. My lord, this is not
Just you are plaintiff in that.
I'm the
suit.
defendant.
Defendant.
We are the defendant in the suit.
So the order was recalled.
My lord, form and substance of the order is the suit was proceeded ex parte against the defendants. Subsequently, my lord, being the defendants, we have filed an application under section 151.
Just a minute. But order was recalled, but your application under Order 39 Rule 4 was kept pending.
Yes, my lord. That is for vacating of the injunction order that is kept pending, my lord. The difficulties occurred, my lord, after this order passed. On 7th February 2026, my lord, some of the police personnel went to the property where we are conducting the business, asked, my lord, not to interfere with the peaceful possession of the private respondents and not our right of ingress and egress in our property was restrained by the police authority. They are saying, my lord, they are implementing the order of injunction passed by the learned court, my lord. On 7 February, after coming to know with that direction was passed maybe by the learned court below, my lord, I have searched before the learned court, my lord. There was no order of implementation passed by the learned court, my
Then
lord.
what happened on 1st September 2025?
1st September 2025, my lord, suit was proceeded ex parte. I have filed an application under section 151 of the Code of Civil Procedure. My lord, that order was order dated 1st September 2025 was recalled by way of order dated 14th of December 2025. Subsequently, my lord, this order is being shown by the police authority as the order of implementation. My lord, at this point of time, if we are trying to go to our property, ingress and egress in our property where we are conducting the business, tire business, my lord, they are saying, my lord, we cannot, and if we will go to my property, my lord, they will keep me under the custody. That was my grievance, my lord. And my only humble submission, only humble submission, my lord, police shall not interfere in my peaceful possession, because, my lord, the order of injunction which was passed and in existence before the learned trial court below, in only with respect to, my lord, one thing, my lord, we shall not interfere with the peaceful ingress and egress of the private respondents, my lord. If
Yes. Mr. Acharya, how police can do this? Where is the order impacting ingress and egress of the
I have
petitioner?
taken the instruction, if your lordship kindly. Go to the next page, first page is my lord.
Yes.
Next page, with the instruction.
Next page. Which paragraph?
My lord, my lord, the paragraph one, two, three, last but fourth paragraph. Case was initially endorsed.
Which paragraph? The case was
This case
initially endorsed. Just a minute.
The case was initially to assistant sub-inspector.
Just a minute. Yes, charge sheet was filed. The law will take its own course. But how on what basis police authority is obstructing so far the ingress and egress of the petitioner is concerned?
Well, we had the, my lord, the.
Where is the material before the police authority? Show me.
Instruction. Your lordship, my lord, this is my instruction, your lordship also.
So far the police, so far the criminal proceeding that is based on in connection with which the charge sheet was submitted on 26th February 2026 under certain sections of BNS. Court is not saying anything. Police authorities can do this, but it is Domjur PS case number 98/2026 dated 9th February 2026. But on what basis the police authority is obstructing the petitioners in ingressing or egressing to their land in question or to their property in question?
This is their allegations. That police is obstructing
in ingress and egress.
Lord, may I?
Then they allow them, allow the petitioners
Here
to.
is different. If your lordship kindly have a look, page 26 of the prayer.
And nothing is
the
nothing is
mandamus prayed for?
disclosed in
What
your
is the
report.
mandamus prayed for?
Nothing is disclosed in your report with regard to ingress and egress.
So this is their allegation. Now, my lord, kindly have a look, page 26.
So you are not obstructing.
That instruction I have to take, my lord. I will come back.
We will take instruction.
My lord,
May I-
only one
may I-
thing, my lord.
My lord,
I have
kindly,
to respond.
kindly have a look, my lord, page 26 once.
I am asking you that where is the material? Where is the court's order impacting the right of the petitioner ingress and egress?
Lord, may I, my lord?
Where is the material, Mr. Acharya? Yes.
But I'm for the respond number 9, my lord. My lord, the dispute, my lord, emanates, my lord, with respect to, my lord. My lord, the dispute emanates, my lord, with respect to, my lord. RS Rag number 40, my lord. I have to construct a road, my lord, connecting, my lord, the other plots with the national highway. An agreement to sell was.
You go on with the dispute.
No, my lord.
You get the issue settled by the order of the civil court or any other authority. To that extent, court is not saying anything. But if it is impacting the right of the petitioner to ingress and egress, in that event, show me the material
I am.
which prevents the petitioner to use their right of passage to their own land.
Lord.
Please wait. Own land in question.
My lord, the petitioners, my lord, were obstructing, my lord, my free ingress and my lord, the construction, my lord, of the road, my lord.
Where is the order of the civil court?
My lord, the
That petitioner will not be permitted to enter into their own land.
It's not.
Or
my lord,
petitioners
anything-
are
my lord,
restrained.
if my lord may
Where
kindly,
is the order?
if my lord may kindly come to page 86, my lord, once. My lord, I am, my lord, placing the, my lord, the order of injunction, my lord. The defendant numbers 1 and 5 and their men and agents are hereby restrained from creating any disturbance to the free movement of the plaintiff.
136.
My lord,
My lord,
86.
page 86, order of injunction.
That has been recalled.
No, my
No,
lord,
no, no, not the order of injunction was recalled, my lord.
free movement of the plaintiffs and its men and agents to use the first schedule.
Just a minute.
And my lord, may I kindly read, my lord, read page 53.
Then the order dated 1st September 2025 is recalled.
Yes, my lord. That was.
That is different.
And you are relying upon which order?
1st of October 2024,
Page?
page 86. Right there.
Yes.
But I'm not going into my lord, the facts. My lord.
Just a minute. Yes. Yes.
But if my lord may now, my lord, kindly
But
take page
that is
53.
that is that the plaintiff defendants number 1 to 5 are restrained. So far, petitioners is concerned relating to ingress and egress.
Now, my lord.
But that is not the allegation. Allegation is that the petitioners are being restrained.
Now,
ingress and egress to and from their land.
Now, my lord,
where is the material based on which you can prevent?
now, my lord, the
And allegation is not against you. Allegation is
No, my lord,
against the
it's
police authority.
not against me.
Police is doing this. On what basis? Where is the material?
Lord,
Mr. Acharya.
Lord, we have, my lord,
Isho.
Lord, we
Another
have,
thing, my lord.
I will hear you later. Sorry. Matter is heard in presence of the learned advocates representing the petitioner, state respondents and private respondents. Stop. Stop. Next paragraph. Learned advocate for the petitioners alleged that a concerned police authority has taken steps against the petitioners, thereby affecting the right of the petitioners to ingress and egress to and from their land in question. Stop. In this regard, reliance is placed on the order dated 10th December 2024 passed by Civil Court in title suit number 1363 of 2024, which is at page 156 of the writ petition. Stop. Query is, next paragraph, query is posed to the learned advocate representing the state respondents that where is the material based on which police can take such steps. Next paragraph, learned advocate for the state respondents has prayed for accommodation to obtain instruction. Stop. Hearing of this matter stands adjourned. List the matter under the same heading for further consideration on March 2026.
Police is taking steps pursuant to proceeding drawn under 163 which I handed over just now. That is the police has been directed to restrain
Police comes with an instruction.
the petition does
Let the
not
state you reserve your energy.
A copy of report may be handed over, my lord.
Affidavit of service filed on the report. The report became.
My lord, a copy of.
They say I am not satisfied with your report because the allegation. अच्छा ठीक है लिखे दो. देखी report देखी. Report filed on report prepared by the inspector in charge, Domjud Police Station, Howrah Police Commissionerate, dated 6th March 2026, is filed by the learned advocate representing the state respondents, and same is taken on record.
My lord, a copy of report may be handed over, my lord.
No, not at this stage.
Grateful.
Yes, yes, call the next.
6, my lord, I am for the petitioner.
Your statement.
My lord, the private respondents illegally encroached my property, and
Have you served upon private respondent?
I have only difficulty I have served yesterday.
Then 48 hours notice is not complete. File your affidavit of service and issue. Learned advocate representing the petitioner has prayed for accommodation. File to complete service of notice upon the respondents and for filing affidavit of service. Next paragraph. Hearing of this matter stands adjourned. Literally, state respondents are represented by learned advocates. Next paragraph. List the matter under the same heading for further consideration on 17th March 2026.
My grateful.
Lordship, I'm appearing for the petition. Lordship, I'm led by Mr. Rajdeep Majumdar in this.
Yes.
Lordship, I'm led by Mr. Rajdeep Majumdar in this case. Lordship, I'm seeking for a short passover in this matter. He's on his legs.
Lordship, I have the instruction, Lordship, appearing for the state along with Shapun Banerjee. Lordship.
Eight, my lord, I am for the petitioner. I am paying for a short accommodation just because of one reason, my lord. One of the private respondent number 9 I have served, but it returned back with an endorsement that addressee cannot be located. So, my lord, if your lordship, my lord, directs me for a further service, my lord, I will.
There are 3 private respondents.
My lord, private respondent number 9, my lord.
At the time of call, learned advocate representing the petitioner prays for accommodation to complete service of notice upon the respondents. Next, however, state respondents are represented by learned advocate. Next, learned advocate for the petitioner is directed to complete service of notice upon all the respondents by 10 days from date and file affidavit of service with district by fortnight from date. And file affidavit of service on the next date. List hearing of list the matter under the same heading for further consideration on 30th March 2026.
Great.
Next. Private respondent. 6. 6 actually.
The petitioners before your lordship, Lord, they are the owners in respect of a 10-kata plot of land. And Lord, the first petitioner is Lord, a registered power of attorney holder. Now, Lord, when
private respondents,
Lord, I have served.
Number 6 only. Because 7 does not 5 does not exist.
7?
7 also does not exist. Why I may say so, your lordship? Finally comes to the cost title. Number 5, Adi Jadavpur Sarvajnik Duর্গোৎসব, a registered association. It is a registered trust. It is not an association. And I am the president of the association. And the order they have obtained, that is also, there is not anywhere mentioned it is a trust, association or anything.
Yes, yes, Mr.
My Lord, so far as Lord, my allegation are concerned, Lord, when we went, Lord, to give Lord a boundary wall, Lord, I was Lord restrained by Lord a number of people, of which Lord the private respondents were Lord the part and they instigated. So Lord, I was compelled to lodge a FIR, and Lord, I also filed a civil suit where there is an order of injunction. Your Lordship may kindly come to the order of injunction, which also directed that the police should give me help, Lord, at the time of implementation of the order of injunction. Lord, may I just take your Lordship, Lord, to the order of injunction first?
Page,
Lord, at page 126. Lord, kindly see, Lord, the last, Lord, last 3 lines. Let the copy of the order be sent to the officer in charge. or Jadavpur police station to take necessary action as and when required for implementation of the instant ad interim injunction order. And Lord, the order is, Lord, that after the ordering portion.
Just a minute.
Lordship.
Suit at your instance.
At my instance.
An ex parte order.
That was ad interim ex parte order of injunction. Now, Lord, my learned friends, I do not know whether they have contested, but this injunction order is still in force as of today.
What happened on 26 February 26?
That was not extended.
In presence of the defendant.
Lord, I have complied, Lord, the requisites by filing, Lord, the plaint and the copy of the injunction. Then my learned friend has already, Lord. So, Lord, as of today, the injunction is in force. Now, Lord, I gave a letter.
This injunction is implemented by dint of the order to be passed in the in this writ petition. What will be decided in the vacating application?
Lord, I tell you, Lordship. Lord, there are two things. Lord, as of today, my learned friend do not come and contend that they are the owners of the property. Lord, the property belongs to, Lord, my clients, no doubt about it. I have got, Lord, documents to show.
The process of law should be followed.
That is.
Yes.
That is.
Right.
So, Lord, as of today,
there is a vacating application pending in connection with the suit. Let it be decided, Mr. Mukherjee.
Lord, as of today, Lord, kindly visualize one situation, Lord, that this is an open plot of land. Lord, I am protecting, Lord, the property which as of today belongs to me. Now, Lord, I am
only this. If boundary wall is erected and construction is made over the suit property or suit land, in that event, what will be decided in the suit itself?
But kindly have a look into the prayers of the suit. Your Lordship will kindly have a look into the
90 years puja, Your Lordship.
It doesn't mean, Lord, that the for
Adverse
90
possession
years,
is
Lord,
there.
that they have become, Lord, the owners of the property.
Adverse possession, ownership by adverse possession, we will be claiming that.
Adverse possession is not automatic.
No, it
Lord,
is
they
not
have to, Lord, apply before the court.
Decide it.
Hey,
Whether
this
it's a
suit
case of
will be
adverse.
decided.
As of today,
So let the suit be decided.
Lord, as of today,
Great.
I tell your Lordship, Lord, whether, Lord, adverse possession, they get title, or as of today, my client do have a title.
I am thinking one step ahead.
Lord, for
Suppose
5 years,
Suppose application for vacating under order 39 is not entertained.
Lordship.
Then this order passed on 27 January 2026 survives.
Yes.
Survives.
There are two things.
Survives. In that event also, if you come before this court praying for police help for implementation of this order dated 27 January 2026, then that will virtually dispose of the suit itself.
No, Lord, in my respectful submission, why I say it is no. Look, because if your Lordship kindly comes to page 110, kindly have a look into, Lord, the scope of the suit. It is for a declaration that we are the owners in respect of the property. And, Lord,
Prayer B.
pursuant to, Lord, the prayer B,
Construction.
That, my lord, there is a
Court
construction.
accepts on the premise, Mr. Mukherjee, that they are the squatters.
Yes.
Lordship.
But due process of law should be followed in evicting them.
But they are not occupying that property.
Why
That is the reason.
Bid court will jump upon it.
No, I only pray before your lordship that, my lord, I have given a letter to the police authority, my lord, asking for, my lord, police help upon cost. That they should decide. Either the police has to, my lord, decide on my letter, the last letter which I have given them. I say I'll put in the police cost.
See, the order is passed by the civil court on 27 January 2026.
Lordship.
Now, if that is not complied with, then you are required to take this issue before the civil court.
But the civil court's order itself
High
contains.
court will not take the responsibility of implementation of the
No,
order. of the
I do not say so, my lord. Your lordship will kindly see without, my lord, that 126 last portion of the order,
When the suit-
I would not have approached
I-
before your lordship.
When the suit is not decreed.
But your lordship expect me to wait for 5 years for the suit to be decreed, and
Yes.
in the meantime, lord, my property
Yes,
will be
yes,
wasted.
Yes, Mr. Mukherjee. Otherwise, if today court directs and the boundary wall is erected, construction is made on the suit.
I do not
suit
say
land,
not for construction. I only say about the
ultimately,
boundary
if
wall.
the suit fails, then what will happen?
But with the accretion, the property will go to whoever it belongs to. But in the meantime, lord, I am entitled to protect the property. Kindly visualize one thing, lord, that today, lord, this is a 10-kata plot of land. It is open land. Nobody occupies as of today. I am the, lord, the owner of
You
the
have
property.
filed an application under Order 39, Rule 4.
Yes, for vacating.
For vacating.
Yes, your lordship.
Sorry, Mr.
Lord,
Mukherjee.
Lord, may I just, lord,
Matter is heard in presence of the learned advocate.
Lord, may I just, lord,
representing the applicants, representing the petitioners, comma, state respondents, and private respondents. Stop. Mr. Probal Kumar Mukherjee, learned senior advocate representing the petitioners, has placed reliance on the order dated 27 January 2026, passed by civil judge within bracket junior division, close bracket 4th court, Alipur, whereby defendants in title suit number 102 of 2026 were restrained from making any disturbance, comma, hindrance, obstruction, comma, disturbance, comma, hindrance, comma, obstruction in construction of boundary wall upon the suit property, and also from creating any obstruction or hindrance for construction of the proposed building in respect of the suit property as described in the schedule property as described in the schedule property in interim petition and plan till 26 February 2026. Stop. It is submitted on behalf of the petitioners that on 26 February 2026, order passed by the civil court on 27 January 2026 was extended. Stop. Petitioner prays for police assistance for implementation of the order dated 27 January 2026. Next paragraph. Private respondents are represented by learned advocate who has submitted that an application seeking vacation of the interim order dated 27 January 2026 under Order 39 Rule 4 is pending before the civil court, is pending before the court below or before the civil court, and same is yet to be decided. Stop. Next paragraph. State respondents are represented by learned advocate. Next paragraph. Having considered the respective submissions made on behalf of the parties, if court proceeds on the premise that the order passed by the civil court on 27 January 2026 still subsists, in that event, court cannot ignore pendency of the suit as well as connected application seeking vacation of the interim order dated 27 January 2026. Stop. Today, if a direction is passed, if mandamus is issued in entertaining this writ petition, directing the concerned police authorities to provide assistance for implementation of the order dated 27 January 2026. In that event, nothing shall be left to be decided in vacating application and the suit itself. Stop. In view of aforesaid consideration, this court is not inclined to interfere with the writ petition. Writ petition stands dismissed. Urgent of circuit. Grateful, Your Lordship.
Much obliged.
Affidavit service filed on behalf of the petitioners is taken on record.
May I beg to appear on behalf of the state respondent?
Yeah,
State respondent.
for the petitioner, madam, there is a private respondent. It was not served, madam. I prefer what
My lord, order of status quo is there, my lord.
24 this month fixed. So I prefer that
Your first matter is fixed when?
24.
24.
Lordship.
Serve notice upon the private respondent.
Lordship.
Yes.
My lord.
Mr. Farmania,
My lord.
where are you? You are in Kolkata or in outside Kolkata?
My lord, I'm at Delhi, my lord, right now. My lord, if I will be there in Kolkata, my lord, I will.
From Delhi.
My lord, I will come in next week, my lord.
At the time of call, learned advocate representing the petitioner prays for accommodation to complete service of notice.
Lordship.
However, state respondents are represented by learned advocate who appears on virtual mode. Stop. Next paragraph. Let the service of notice upon all the respondents.
Lordship, I shall serve all the respondents.
Be made complete and affidavit of service be filed on the next date. Next paragraph. List the matter under the same heading for further consideration on 24th March.
24th March.
On 24th March 2026.
Lordship, good.
Obliged, my lord.
Next.
Good work.
My lord, in this case, I am for the petitioner. My lord, I have served copy on all the state respondents, but due to infirmity of India Post, though I have posted on 28th February, but 3 private respondents had not been delivered yet. My lord, I seek permission to accommodate the matter in the next week, next Friday.
Service is not complete.
Only the private respondents have not been served due to the infirmity of
We are
India
for the
Post.
state. Issue. At the time of call, learned advocate representing the petitioners prays for accommodation to complete service of notice upon all the respondents. Next paragraph. However, state respondents are represented by learned advocate. Next paragraph. Learned advocate for the petitioners is directed to serve notice upon upon all the respondents and file affidavit of service on the next day. Hearing of this matter stands adjourned. List the matter under the same heading for further consideration on 24th March 2026.
Obliged, my lord.
Okay.
Madam, for the petitioner.
Lordship, in this matter, I received the petition yesterday, Lordship. I have not yet.
Service is
received any
complete.
instruction.
Well, in regard to the private respondents, my lord, on 2nd of March, I have served, my lord, but till date, the track report, it has not taken out, my lord. Well, it is not showing in the website.
Issue. At the time of call, learned advocate representing the petitioner prays for accommodation to complete service of notice upon all the respondents. Next paragraph. However, state respondents are represented by learned advocate. Stop. Next paragraph. Hearing of this writ petition stands adjourned. Learned advocate for the petitioner is directed to complete service of notice upon all the respondents and file affidavit of service on the next date. List the matter under the same heading for further consideration on 30th March 2026.
30th.
Next.
I'm grateful to you.
May it please your lordship. Well, this is my petition, my lord. Service is complete.
I have instruction to appear on behalf of the private respondent number 6 and 7.
On behalf of the state. Yes, that your lordship received the brief, but no instruction as yet now.
State adjournment.
I will obtain instruction not today.
Tomorrow had been fixed for hearing their application from the lower court.
Court will hear the petitioner on the next day. He is praying for time. So let it be on Wednesday.
Very well, my lord.
Not on Monday, other matters.
Yes, yes. I'm grateful.
Take back your affidavit of service, file it on the next day.
I'll do that, my lord. I'm grateful.
Thank you. Number please.
On Wednesday.
Number country.
Well, regarding item number 12, my lord has fixed it on 30th of March. Well,
If you bargain, then I will direct the matter to appear in the next monthly list.
I am not bargaining.
Yes.
My lord.
What time, Lord, I'm petition. I'm for the state. Lord, in this matter, my very short prayer, my lord. The police authority over telephone threatened if he not come before the police station and meet up the litigation with the, my lord, some person, private respondent, instigate. Without notice over page number 3, paragraph number 4, telephone number, time, my lord, mentioned. If there is a case, specific case, my lord, it should have notice, 41 notice. Obviously, I will go to the police station. But I do not know whether I'm not in a position to ascertain that what case against me, if any case filed or not me. Just like acting as a mediator. I made a representation, my lord, and after receiving the representation also, my lord, over telephone, my lord, checked.
But your complaint is against one Lokhirani Sardar.
Lokhirani over telephone stated that you receive money from the Lokhirani, you come and meet up the situation. Otherwise, I will arrest you, something like that. If there is a specific case, I have no objection. But in collusion with the private respondent, police over telephone, asked to come.
This Lokhirani lodged a complaint before the police station. Initially, it was a GD inquiry.
Initially, it was
GD entry. There was a general diary entry. We tried to contact the petitioner. We reached there, his place, but he was not there. He was absent. We lost another GD entry intimating that it is in our record that we went to his place. Now, we tried to contact him over telephone. We did not. Thereafter, we received another court order from the London Magistrates Court regarding the lodging of FIR. We started a specific FIR against him. Thereafter,
lodging of FIR by Lokhirani.
Lokhirani against the petitioner. After receiving that order, we started the FIR. We have done nothing, my lord. Thereafter, we never telephoned him, nothing. And with regard to the issuance of 35(3) or 41 notice, that cannot be done because, my lord, this is a, my lord, sections are 420 or 406, more than 7 years. So there is no requirement of serving notice. Well, I have the FIR and the complaint with me, my lord.
420, 400.
Why you are threatening
No,
over
no threat, my lord. There was, after receiving the complaint from Lokhirani, we initiated a GD, general diary complaint. And after receiving the general diary, we tried to contact him over telephone so that what has happened, we actually wanted to know, my lord. May I handle it?
Kindly, my lord, direct to file an affidavit opposition.
No, my lord.
Opposition, my lord. My lord, what is the provision, my lord? My lord, in my practice, my lord, I don't know, my lord, that over telephone, police can ask me to come, otherwise I will arrest. But I know the provision.
Please, yes. Please.
For 406, 7 years, up to 7 years. Okay.
Already,
My lord,
criminal
kindly.
proceeding was initiated, being Matia PS case number 72/2026 on 26 February 26. Twice, police authority, police went to your residence and you were found unavailable, and you, in spite of making attempt by the police authority, you did not meet the police authority.
Yes, my lord, kindly.
And there was a complaint.
Yes, my lord. What is the
Court at this stage
what is the provision? My lord, what is my lord, no, my lord, what is the provision? Learned friend, my lord. No, no, learned friend, my lord, submitted before your lordship under section 420, 406. But both section within 7 years. Within 7 years, police bound to issue a notice under section 41A. If police issued a notice, in spite of that, police return the, thereafter police went there, my lord, I have no case. But it is required to produce there is any notice issued by the police authority or not. 420, 406 within 7 years, my lord. Within 7 years, police is duty bound to issue notice. My lord, Arnes Kumar judgment clearly said. It is, my lord, asked any notice issued or not. In spite of issuing notice, if not available, in that case, police went there.
Why you are not issuing notice?
My lord, kindly,
41
my
and
lord,
notice.
kindly consider the aspect. If it is a FIR initiated by the police itself, then in that event, I am bound to issue a notice. It's a court complaint. Court has directed me to issue an FIR. Yes, what? No. This is the. I have handed over the order of the court. That is registered court. Then I am not bound to give a notice.
My lord, I
kindly consider the aspect.
My lord, I appeared several occasions before the
I have
criminal
also
court.
tried to appear.
Criminal
Lord, I
court.
will, my lord.
Several occasions.
You have not brought that, but
the provision
Lord,
from BNSS.
Yes,
my lord.
Several occasions, my lord, I appeared. Police only.
Please wait. Several occasions you
No,
appeared
my
is
lord,
not a point.
magistrate only direct to lodge an FIR.
Show me the provision.
My lord.
That without issuing 41A notice, police can direct the petitioner to meet the police
Much
authorities or to appear before the police authorities.
No, my lord, what happened here, my lord? There is a difference, my lord. Here, my lord, after receiving the complaint from the Lokhirani, we tried to contact him.
Yes.
At that point of time, there was no FIR.
Occasions that you have discussed in your
There were no FIR at that point of time. After that, my lord, the Lokhirani appeared before the London magistrate. There was an order for initiation of FIR by the London magistrate upon the police authority. Upon pursuing that, my lord, we have started the FIR. Not that we ourselves so satisfied with the complaint and started the FIR. In that event, we are bound to give him notice. We are bound to give him 41 notice as per the Honest Kumar judgment. We cannot escape from that, my lord. But here, my lord, the court has ordered us to record an FIR, start an FIR.
No, that is not the case. Here it is based on the complaint, subsequently on the basis of the written complaint lodged by the Lokhirani Sardar, PS case number 7226 was registered. Now, yes, this is not in terms of the order of the magistrate, this proceeding is initiated.
My lord.
If that is so, if it is based on the complaint, 41A notice is not required to be served, you show me the provision.
My lord, may I come back with short? Yes. Even to Monday, my lord. There is no difficulty. I will come back with that.
Tuesday.
As your lordship.
But if I
Simple thing. He is taking the point. It's a point of law that without
why not notice will be there?
Issuing 41A notice, police authority should not call the petitioner to meet to appear before the authority.
My lord.
You are saying that that is not required in the present case. Facts of the case.
My lord,
had it been a case initiated in terms of the order of the magistrate, in that event 41A notice was compulsory. But since it is based on the complaint lodged by one Lokhirani Sardar, the proceeding was initiated, that is PS case number 7226. There 41A notice is not warranted. Without 41A notice, police can call the accused to meet the police authority.
I have understood.
Where is the provision?
I have understood what is fallen from laws. May I come back on that?
You know, in both the cases, 41 notice is required to issue. In both the cases.
Matter is heard in presence of the learned advocates representing the. Where is your affidavit of service?
Affidavit service kept to the private respondent received.
Received?
Yes, sir.
When received? Every service to down to? Onake to down to?
These are the.
When received?
27th, 2nd March, my lord. 2nd March. 2nd March.
2nd March. 48 hours is.
Today, my lord, 6th.
Because there was intervening holidays. 5th, then 6th. Affidavit service file it. Affidavit service filed on behalf of the petitioner is taken on record. Stop. Matter is heard in presence of the learned advocates representing the petitioner and state respondents. Stop. However, respondent number
26.
Respondent numbers 4 and 5 are not represented today. Stop. Next paragraph. A report prepared by Inspector
5 is a sub inspector
of Police IC Matia Police Station or Inspector in Charge Matia Police Station, Boshirhat Police District, dated 6th March 2026. A report prepared by Inspector in Charge Matia Police Station, Boshirhat Police Commission, Boshirhat Police District, dated 6th March 2026, is filed today and same is taken on record. Next paragraph, learned advocate representing the state respondents has prayed for accommodation. Stop. Hearing of this matter stands adjourned. List the matter under the same heading for further consideration on.
And both of the foreign
16th March 2026.
Ajulot. But one thing I must indicate, Milord, though it is nomenclated as
Learned
report.
advocate for the petitioner is directed to serve notice enclosing copy of this order upon respondent numbers.
Milord, 5 is a sub inspector, only 4. 5 is a sub inspector, Milord. He is appearing.
He is conducting. No, I will not. I cannot appear, Milord.
Then, Milord, I will serve, Milord.
Upon respondent number 4 and 5 is the sub inspector.
Milord, by name he has been made party. I cannot appear.
Upon respondent number 4.
Milord. But though it is nomenclated as a report, but it's a instruction to the state advocate. Milord. Kindly clarify that, Milord.
Yes.
Though it's a nomenclated as a report by the IC, but it's a instruction to the state advocate, Milord. But address to the landed government.
It's not a report of
its Milord. It has been nomenclated wrongly, Milord. It has been written as to the landed government.
Instruction.
Now, a communication dated 6 March 2026 of Inspector in Charge Matia Police Station.
Milord. Grateful to you.
Boshirat Police District, dated 6 March, Boshirat Police District is filed today and same is taken on.
Grateful to us. Much.
Ha. No.
And for the state respondent, my lord. But I need some time to obtain instruction in this matter.
Yes.
I need some time to obtain instruction.
Where is
in
this petitioner?
Instruction. I'm fine here. 15. 15. 15.
At the time of call, no one appears for the petitioner and no accommodation is paid for. However, Union of India.
State of Israel.
However, state respondents are represented by learned advocates. Stop. In order to grant one more chance to the petitioner, hearing of this matter stands adjourned. List the matter under the same heading for further consideration on 16th March 2026.
Great.
Next.
My lord, in this matter,
I
I am for the petitioner. I am praying for the accommodation.
You are for
the respondent number 4.
Who is respondent number 4?
But I am the accused.
Private respondent.
But the petitioner is the holder of a license under me.
Yes, license?
Under me.
Licensee under you. You are for the state. Well, come back next Wednesday, not Monday. Adjourn till Wednesday. Record an order. At the time of call, accommodation is paid for by the learned advocate representing the petitioner. However, state respondents, you are for the state. However, state respondents and respondent number 4 are represented by learned advocates. Stop. Hearing of this matter stands adjourned. List the matter under the same heading for further consideration on. Let it be on 16th March. On 16th March 2026.
16th March.
16th March. নম্বর
My lord, due to sudden death of mother of Mr. Mogaram Hussain, today he was present in court, my lord. He left this court, my lord, immediately.
He is the advocate on record.
Advocate on record.
I am appearing on behalf of the private
Only
respondent
7
number
days
6.
time, this matter will remain in the same position. This is the
But is Mokaram Hussain
Mokaram Hussain.
His father died.
Mother.
Issue. At the time of call, accommodation is paid for on behalf of the petitioner on the personal ground of the learned advocate. You are for the state.
Private respondent number 6 and 7.
Next paragraph. Private respondent number 6 and 7 are represented by learned advocate. The hearing of this matter stands adjourned. List the matter under the same heading in the monthly combined list of April 2026.
Supplementary list after 7 days, my lord.
Yes.
Supplementary list after 7
No, certainly not.
Much of.
I do not bring the matters unless there is an exceptional circumstance. Do not bring the matter from combined list to supplementary list.
Well, due to unavoidable circumstances, this is very unfortunate case.
Next matter. issue. At the time of call, no one appears for the petitioner and no accommodation is paid for. Next paragraph, on perusal of records, it appears on 25th July 2025, a coordinate bench granted adjournment, thereby permitting the petitioner to complete service of notice upon the respondents. Next paragraph. Next paragraph, writ petition stands dismissed for default. Parties are to act on the server copy. Next. At the time of call, no one appears for the petitioner and no accommodation is paid. Stop. Next, on perusal of records, it appears on 25th July 2025. Now, second paragraph. Same situation prevailed on 25th July 2025. Stop. It appears petitioner has lost interest. Stop. Writ petition stands dismissed for default. Parties to act on the server copy. Next.
My lord, Mr. Torunjyoti Tiwari will appear on behalf of the petitioner due to his personal. Torunjyoti Tiwari is appearing on behalf of the petitioner due to some personal difficulty. Couldn't come to the court. I am praying for not today.
But previously on 25th July 2025, accommodation was paid for. How long this matter will occupy a slot in the list?
I don't have a proper.
Matter will not be taken up as per sweet will of the learned advocate.
Yes.
So how long this will continue? On 25th July, coordinate bench granted adjournment on the prayer made by the learned advocate representing the petitioner.
Yes,
I am adjourning the matter for 7 days, pay a cost of rupees 70,000. Issue. At the time of call, accommodation is paid for on behalf of the petitioner on the ground of the learned advocate. Next paragraph. Hearing of this matter stands adjourned. As a last chance, hearing of this matter stands adjourned. Stop. It is made clear that on the next date, no adjournment shall be granted. List the matter under the same heading in the monthly combined list of April 2026. Next.
Milord, I am for the state respondents in this matter, Milord. This matter pertains to an alleged deed which the petitioner claims to have been forged.
At the time of call, no one appears for the petitioner and no accommodation is paid for. However, state respondents are represented by learned advocates. Next paragraph, on perusal of records, it appears on 25th July 2025 on the prayer made on behalf of the petitioner. Hearing of the writ petition was adjourned. Stop. Next paragraph, writ petition stands dismissed for default. Parties to act on application. Dismissed for default application, comma, if any pending, comma, also stands dismissed.
The reports need not be submitted.
It's not required. Parties to act on the application. Parties to act on the server copy. Next.
Lordship, I am on behalf of the petitioner, Lordship.
Yes.
Lordship, with the Lordship's order, with the Lordship's permission, I am filing the affidavit of service, Lordship. The brief.
Other side. Mr. Shishano Bandyopadhyay and Devopriyo Karan. This old service.
Lordship.
To serve another notice and come back.
সার্ভিসটা কবে হয়েছে একবার দেখে নিই তো সার্ভিসটা কবে হয়েছে 11/7/2025
Old service.
Old service.
Up before change of determination.
Before change of determination.
Affidavit service. Affidavit service filed on behalf of the file your affidavit of service.
Already I have filed, Lordship.
Affidavit service filed on behalf of the petitioner is taken on record. Respondents are not represented today. Next paragraph, line advocate for the petitioner is directed to serve notice upon all the respondents. Directed to serve notice upon the respondents or all the respondents upon the respondents or the learned advocate representing the respondents, enclosing copy of this order by fortnight from date and file further affidavit of service on the next date. Next paragraph, list the matter under the same heading.
Lordship, by strength of this order, Lordship,
the combined list of April 26.
By strength of this order, I will serve the notice along with the order.
Yeah, and if advocates are there, you can serve notice of
Lordship, but petition service of petition is not required.
Not required.
Not required. I am deeply obliged, Lordship. I am deeply obliged.
Next matter. At the time of call, no one appears for the petitioner. You are appearing for the petitioner?
No,
At the time of call, no one appears for the petitioner and no accommodation is paid for. Stop. Next paragraph, on perusal of, you are appearing for the state in this matter. On perusal of records, it appears on 8th of July 2025. A coordinate bench adjourned the matter, thereby permitting the petitioner to serve notice upon the respondents. Next paragraph. Writ petition stands dismissed for default, parties to act on the server. Next. Yes, Mr. Bosu, you are for the state. Issue. At the time of call, no one appears for the petitioner and no accommodation is paid for. However, state respondents are represented by learned advocates. Next paragraph, on perusal of records, it appears on 25th July 2025, a coordinate bench on the prayer made on behalf of the petitioner adjourned the matter. Stop. Writ petition stands dismissed for default. Parties are parties to act on the server copy. State. Private respondent. Which respondent? Respondent 12. 12. Issue. At the time of call, no one appears for the petitioner and no accommodation is paid for. However, respondent number 12 is represented by learned advocate. Next paragraph. Same situation prevailed on 25th July 2025. Stop. It appears petitioner has lost interest. Stop. Writ petition stands dismissed for default. Parties to act on the server.
In this matter, I am for the petitioner.
And I am for the state respondents.
Any private respondent?
Yes, man, there are certain party of private respondent. Here is the
Then you have
evidence.
to serve notice again. It's an old writ petition of 2025.
Yes, man. It is old service, man.
Old service.
Yes.
File affidavit of service. Serve fresh
let this be
notice
kept on
upon the
record.
private respondents or the learned advocate. If anybody represents the private respondents, and come with you. Issue. Affidavit of service filed on behalf of the petitioner is taken on record. Stop. In spite of service of notice, respondent numbers 5 to
13
are not represented today. Five state respondents are represented by learned advocates. Next paragraph, learned advocate for the petitioner is directed to serve notice upon non-appearing respondents or the learned advocate representing those respondents, including copy of this order by fortnight from date, and file affidavit of service on the next date. List the matter under the same heading in the monthly combined list of April 2026.
I'm right. Well, let the evidence of service be kept on the record.
Yes, I have recorded.
I'm obliged, man.
Grateful, my lord.
None. দেখুন সুমন ঘোষ সুমিতা শাহ At the time of call, no one appears for the petitioner and no accommodation is paid for. Stop. Same situation prevailed on 25th July 2025 before a coordinate bench. Stop. It appears petitioner has lost interest. Stop. Writ petition stands dismissed for default. Stop. Parties to act on the server copy.
Matter, I am appealing for state respondent. This instant writ petition filed for police overaction, but my lord.
Issue. At the time of call, no one appears for the petitioners and no accommodation is paid for. However, state respondents are represented by learned advocates. Next paragraph. On perusal of records, it appears on 28 July 2025. A coordinate bench granted leave to file granted leave to the petitioner to file supplementary affidavit. Stop. However, till date, no supplementary affidavit is filed. No, however, till date, supplementary affidavit is not found on record. Stop. Writ petition stands dismissed for default. Parties to act on the server copy.
May I file the report, madam?
Not required since I am dismissing for default. If it is on merit, then I would have considered your report. At the time of call, no one appears for the petitioner and no accommodation is paid for. Next paragraph on perusal of records, it appears on 28 July 2025. A coordinate bench granted adjournment on the prayer made on behalf of the petitioner. Stop. Writ petition stands dismissed for default. Parties to act on the server copy. State. At the time of call, no one appears for the petitioner and no accommodation is paid for. However, state respondents are represented by learned advocate. Next paragraph on perusal of the records. On perusal of records, it appears on 28 July 2025. A coordinate bench granted adjournment on the prayer made on behalf of the petitioner. Stop. Stop. Next paragraph, writ petition stands dismissed for default.
I appear for the petition. I appear for the petitioner in this matter.
As for the petitioner led by Mr. Akram, and I am praying for not today, madam. Mr. Akram, Wasim Akram.
Where is he?
He is absent today.
Why he is absent? We are all.
I don't have the instruction. He,
Brother
over phone
side is
call.
present.
Over phone call, he has instructed me to take
Yes.
not today. He has instructed me to take not today
On
from
28 July 2025, accommodation was prayed for on behalf of the petitioner. How long this will continue?
Well,
And
in
he is
that-
taking rest at home.
no.
All are working. How long this will continue?
On Monday, my lord, kindly fix.
Yes, according to your sweet will, court will take up the matter. Today he has not come, court will not hear the matter. And on Monday he will come, court will take up the matter, leaving aside all other work. Matter is running in the list. There is an indication in the list that that matters are to be taken up. Why he has not come?
Today he is absent due to some personal difficulty, my lord.
Not today. এটাকে লিস্টে সেম পজিশনে রাখবে তো।
Grateful, lord.
Not today.
For the state, my lord.
Item number 95, my lord, I am praying for leave to appear through online mode, my lord. My lord, last day I am suffering for smallpoxes, my lord. Last day I have appeared before your lordship, but my lord, if your lordship kindly allow me 2 week accommodation, my lord.
At the time of call, learned advocate who is appearing on virtual mode has prayed for accommodation as he is unwell. Stop. However, state respondents are represented by learned advocate. Stop. Acceding to the prayer made on behalf of the petitioner, hearing of this matter stands adjourned. List the matter under the same heading in the monthly combined list of April 2026.
Grateful.
Right, before my lord rises, my lord, item number 93.
My lord, 93.
And I am appearing for that.
I appear for the status. It's a review matter, madam.
Yes. You are seeking review of the order dated 17 June 2019. Now, in terms of this order dated 17 June 2019, you joined on 1st of November 2019 and confirmed on 1st of November 1st of November 2022. Then review filed on 12 April 2021. Now, today we are not considering the question of delay because we have condoned the delay. Now, last occasion it appears that Mr.
Paragraph 17.
Dutt pointed out paragraph, both Mr. Dutt and Mr. Mukherjee pointed out paragraph 17.
That is, he has to get
That
over
it is made clear that if the petitioner accepts the offer of appointment, he shall not be entitled to claim any benefit with retrospective effect.
This is our.
Now, you have not, the appropriate course is to prefer an appeal against this order, at least against paragraph 17. Without raising any demur, you join the post. It's a post of process server. A post of process server you joined. Now, if you have joined without any objection, without any demur, thereafter, where is the question of review? That is the point respondent state as well as district judge is taking.
This is not
And
an
I accepted
ingredient of order
para
47.
17.
Not an ingredient of order 47 at all.
There is no error apparent on the face of record.
17, my lord.
No, nothing. Discovery.
Yes.
My lord, as my seniority affected, for that reason, my lord, the petitioner filed review application, serial number 17, my lord. If serial number 17 modified, my lord, for that reason, only affection of seniority. My lord, because the recruitment process 2013 and petitioner after passing, there are several litigation. First SAT, WPST file before the SAT, then my lord, again High Court, and then High Court given liberty, then again my lord SAT, again my lord WPST. But there are several litigation, and 2022 the petitioner joined as per the order of this Honorable High Court. My lord, if 2013 recruitment process, the petitioner joined 2013, well, then he will be senior, more than senior any other stuffs. For that reason,
but for which, why review? Is it not an appeal in the guise of review?
Yes, Malad, this is Malad. One condition is there: if accepted, para 17, it is made clear if the petitioner accepts. It is true that petitioner Malad accepted the appointment on the basis of this order. It is true.
From which date you are seeking benefit?
2013 recruitment process. And others candidate, my lord, who
What
joined,
is the date when the last candidate in that recruitment process got appointed? Have you disclosed it in your review petition?
my lord, that is not.
Find it out.
By employment notification on 26/2/2013, my lord, candidates has been joined.
The candidate who obtained 87.50 marks. What is the date of his appointment? Where is such disclosure in your writ petition
In my review
for
application,
consideration of this court?
my lord, that was not disclosed in,
Then how this
Page.
court will decide in the review the date of
my lord, only date,
effective?
page 5, my lord, in my grounds number 8, I disclose the date.
Just a minute. Mr. Dotto, please come to paragraph 16, page 40 of the review application. Please place it.
Petitioner appointed as LDA cum cashier purely temporary and on contractual basis.
Paragraph 16. Paragraph 16 of the judgment which is under review. Page 40 of the review application. Yes.
Paragraph 16, yes. Order of the tribunal impugned this writ petition stands set aside. Petitioner shall be treated to have obtained 89.67 marks. The district judge Bakuda is directed to offer him appointment immediately, but not later than 7 days from date, on a vacant post of process server. If no vacancy is available on as on date, the next vacancy shall not be filled up by any recruitment process, but appointment shall be offered to the petitioner first. Should the petitioner fail to accept the offer of appointment within the period stipulated therefore, the vacancy may be filled up in accordance with law. If the vacancy filled up by the petitioner happens to be reserved, such reservation shall be carried forward to the next vacancy and filled up by a reserved candidate through a process of recruitment.
Now the query of the court is, if there is a direction to appoint the petitioner by 7 days from date, but in effect, while considering the facts of this case, it appears that the petitioner joined on 1st of November 2019, though order was passed on 17 June 2019. How do you respond to this?
Lord, in paragraph 13, I believe, paragraph 13, Lordship kindly sees.
Paragraph 13?
Yes, of the petition. The review petition, page 7.
Yes.
That as per the order dated, Lordship kindly, as per the order dated.
Paragraph 13 of the judgment?
No, 13th of the
review petition.
Petition, yes. Page 7. Page 7.
Just a minute. Yes, paragraph 13.
That as per the order dated 17 June 2019, as per the order dated, the petitioner joined his service on 1st of November 2019, and the service of the petitioner was confirmed on 1st of November 2022. So, Malad, this copy of appointment P10, Lordship takes, Malad.
Is it your case that no vacancy was available on the date when this order was passed by the Honorable Division Bench or by the coordinate bench?
Lordship, Malad, if Lordship taking a clue from paragraph 16.
16.
Yes, I read once again.
Yes, read it.
The order of the tribunal impugned the writ petition stands set aside. The petitioner shall be treated to have obtained 89.67 marks. The district judge Bakuda is directed to offer him appointment immediately, but not later than 7 days from date, on a vacant post of process servers. The Lordship's query is not there whether because the offer letter.
The district judge Bakuda is directed to offer him appointment immediately,
but not later than 7 days.
Immediately, but not later than 7 days from date, on the vacant post of process server.
Yes. So, Malad, the timeline was there, fixed timeline.
Now, if no vacancy is available as on date, the next vacancy shall not be.
I'm coming, Malad. Lordship gives me a minute, Malad. Yeah, yes.
In that event, as per assessment of us, 17 June is the date. Then on and from 24th of June 2019, petitioner's pay should be fixed. Now, if you can demonstrate before this court that no vacancy was there at the relevant point of time, therefore, the second part of paragraph 17 was required to be considered, or is required to be considered, where it says if no vacancy is available as on date, next vacancy shall not be filled up
by any recruitment process, but appointment shall be offered to the petitioner first.
Available as on date, the next vacancy shall not be filled up by any recruitment process, but appointment shall be offered to the petitioner first. Should the petitioner fail to accept the offer of appointment within the period stipulated thereof.
Therefore.
That means, therefore, no, that means 7 days.
7 days. The vacancy may be filled up. Section 5, Lordship, my lord, Lordship, my lord,
Now, district judge is in a better position to address this court with regard to availability of vacancy on the date of passing judgment by the coordinate bench, passing order by the coordinate bench on 17 June 2019.
Yes, Lordship, if your Lordship takes, my lord, page 44 of the Section 5 application.
Order number 235, dated 27.
This is of the district
But
judge.
one thing which is also passing through our mind is this, that for that contempt application is maintained. But why review?
My lord, this my lord, review, my lord, I repeat, my lord, that I last
Order
time I-
47 principle.
Order 47 principle, none of the principles of order 40 is abstracted in this case. So that's the one thing. বুঝেছি। ওর অফার একবার অ্যাকসেপ্ট করে নি।
No, because there is a applicant. Similar. Now, cited that this petition is not meant to approach the tribunal. Now, see, at that point of time, it was open to the petitioner to challenge that order of the single bench, that no, tribunal has got no jurisdiction. This is the case which is required to be decided by the single bench of the court. So an intra-court appeal was required to be preferred against the order of the single bench. That petitioner did not do it. That's why this order.
Page 43 once.
Page 43
Lordship.
of the review application.
Lordship. This is my order number 235 dated 27th of August 2019. This is of the learned district judge then. Now, my lord,
It is order number 69 of 7 June 2023. Page 43, annexure P10.
Page 44.
Page 43. No, no,
235, 27th August 2019. Yes.
No, before that. Before that,
Before that, page 43, order number
that is
69.
not the concluding part of that page. It starts at page 43.
Yes, order number 69, 7
No,
June
no, not
2023.
69. This is order number 235 dated 27th of August 19.
Order number?
235.
235, yes, order number 235 dated 27th August 2019 is at page 44.
Lordship, then the page doesn't tell you, my lord. Lordship, may I read for you, Lordship?
Yes.
This is of the then learned district judge, now my lord, honorable judge of this court. Consequent upon receipt of the attested Xerox certified copy of the order dated 17 June 2019 in WPS number so-and-so, Somnath Pal versus so-and-so, as preferred by Sri Somnath Pal, challenging the order of the then learned district judge Bakuda in connection with the recruitment examination in 2013, as he took part in the said examination wherein both the Honorable Justice Mr. Shogata Bhattacharya and Mr. Dipankar Datta of the division bench have been pleased to direct the undersigned to offer Sri Somnath Pal appointment immediately but not later than 7 days from date as a vacant post of process server. Then, as per report of the Saristada District Judges Court, Bakuda, one post of process server is lying vacant since 1st of July 2019 due to retirement of Sri Subroto Pal, ex-process server, District Judges Court, Bankura, on superannuation on 30th of June 2019. The resultant vacancy is urgently required to be filled up by appointment of Sri Somnath Pal with honor to the order of the Honorable High Court, Calcutta.
Yes.
The vacancy falls on 31st point of 100-point roster under West Bengal Scheduled Caste Scheduled Tribes Act 76, which is unreserved one, and the said vacancy is required to be filled up by the candidate belonging to the community of general caste. In these circumstances, there is no legal bar to select Sri Somnath Pal to the post of process server against the vacant post has already occurred. Accordingly, Sri Somnath Pal, son of so is hereby appointed temporarily to the post of process server in the category of summon belief as nomenclature by virtue of recommendation of the City Commission subject to fulfillment of his medical fitness and police verification. Sri Pal is entitled to get the following emoluments for the ends of natural justice, he is directed to take appropriate steps in respect of his medical fitness and police verification with the assistance of the Sahishadar in office. He is to note it that as soon as completion of this above process, he will be permitted to enter into service and to join as process server summon belief in the Nazara department of the District Judges Court, Bankura. Accordingly, the judge in charge of Nazara District Judges Court, Bankura is hereby requested to permit him to join the post of process server summon belief as and when he appears, but completion of the medical process
Police verification.
Period of probation shall be up to 3 years from the date of joining in the said post. Now, a contempt petition was filed.
No.
In the meantime, the appointment was given. Lordship kindly takes the previous page, order number 69.
Just a minute. Just a minute. Contempt for what? For not appointing the petition.
Contempt is not filed. Only notice has been served.
Page 46 or 45.
It's a notice.
Then, my lord, this order number 69, that is the letter of appointment was given. She accepted, my lord, in the on affidavit, he says, as per order of the High Court, I joined the post, I was confirmed in that post. In paragraph 13, I just pointed out. So after that, my lord, this the review is not maintainable in any. He accepted without any demur objection. And on oath, he says that as per order of the court, I joined. This is my afterthought, completely afterthought.
Review application is memorandum of review application is heard in presence of the learned advocates representing the applicant, state respondents, and district judgeship Bankura. Stop. Next paragraph. By presenting this review application, inter alia, applicant has prayed for review of the order dated 17 June 2019 passed by a coordinate bench, whereby writ petition being WPST 46 of 2019 was disposed of. Stop. Petitioner took part in staff recruitment examination 2013 of Bankura Judgeship, but initially he was not selected as Petitioner was awarded 86.67 marks, whereas last candidate who was selected for the post of process servers obtained 87.50 marks. Stop. Questioning the selection process of 2013, wherein petitioner was not wherein applicant was not selected for the post of process server. A writ petition was filed being WPA 17872 WPA 17872 of 2014, whereupon an order was passed on 17 June 2015. Thereby, writ petition was disposed of, granting liberty to the petitioner to approach an appropriate forum instead of preferring appeal against the order dated 17 June 2015 passed on the writ petition being WPA 17872 of 2014. Petitioner approached West Bengal Administrative Tribunal. Petitioner approached West Bengal Administrative Tribunal. By filing original application being OA 825 of 2015, said original application was dismissed by the tribunal on 1st February 2018. By returning an observation, observation that no merit was found in that application. Order dated 1st February 2018 of the tribunal prompted the petitioner to approach coordinate bench with the writ petition being WPST 46 of 2019. Next paragraph. Writ petition was finally heard and disposed of vide order dated 17 June 2019. On scrutiny of performance of the petitioner in answering multiple choice questions, coordinate bench found petitioner was applicant was entitled to benefit of enhancement of marks. Consequently, marks of the petitioner was enhanced from 86.67 to 89.67, which brought the petitioner within the zone of consideration for being appointed in the post of process server in connection with staff recruitment examination 2013 under Bankura judgeship. Stop. However, in paragraph 17 of the order of the coordinate bench dated 17 June 2019, it was clarified that in the event applicant accepts the offer of appointment in terms of the directions as contained in the order dated 17 June 2019, he shall not be entitled to any claim, shall not be entitled to claim any benefit with retrospective effect. Stop. Next paragraph. Without raising any demur, petitioner, applicant accepted said order dated 17 June 2019 and joined the post of process server on 1st November 2019. Stop. Subsequently, applicant was confirmed with effect from 1st November 2022 and 1st November 2022. Stop. After appointment of the petitioner on 1st November 2019 as process server, petitioner filed present review application on 12th April 2021. On 12th April 2021, seeking service benefits from previous date, that is prior to date of his appointment on 1st November 2019, in terms of the criteria. 1st November 2019, by reviewing the order dated 17 June 2019. Stop. Next paragraph, learned advocate representing the applicant submits that if petitioner is found to be eligible for being appointed in connection with staff recruitment examination 2013, then his appointment should relate back to a previous date when other candidates on being selected joined the post of process server. And such relief is prayed for by filing present review application. Next paragraph, it is rightly pointed out on behalf of the respondent authorities. Now, it is rightly pointed out by Mr. Swapon Kumar Dotto, Swapon Kumar or Swapon Dotto? Swapon Kumar Dotto, learned additional government pleader, learned government pleader representing the state respondents, that the appointment of the petitioner, appointment of the applicant was conditional one in terms of the order dated 17 June 2019. In view of the clarification offered by the coordinate bench in paragraph 17 of the review application. Stop. Next paragraph, for better understanding of the next paragraph, for better understanding of the issue, we find it apt to quote paragraph 17 of the order dated 17 June 2019 below. Paragraph 17 take quote kore debu. Set out. Page 41 of the review. Stop. This court cannot brush aside the fact that without raising any demur, petitioner accepted, petitioner joined the post of process server on 1st November 2019 and thereafter filed review application which is found to be afterthought. If petitioner would have been aggrieved by the order dated 17 June 2019, specifically the observation made in paragraph 17 of the said order, in that event, contemporaneous steps ought to have been taken by preferring appeal against the review, against the order dated 17 June 2019. Stop. Relief sought for in this relief sought for by filing review application is found to be impermissible at this stage, and it transpires to us that this is an appeal in guise of review. Next paragraph, moreover, nothing is demonstrated on behalf of the applicant that there is error apparent on the face of record requiring review of the order dated 17 June 2019. Next paragraph, in view of aforesaid conspectus, we are not inclined to interfere with the order dated 17 June 2019 passed by the coordinate bench. Hence, review application is dismissed. There shall be no is dismissed. Urgent Xerox certificate copy.
Another thing, in the writ petition, the prayer which has been made, review more than enough the prayer has been made, because it is beyond the scope of the
review application, review and the connected applications are rejected, are dismissed করে দেবে। এমনি হবে কিন্তু এই শুভেন্দু জাজমেন্ট ফর্মে হবে না।
Lord, I am appearing for the alleged contempt number 4.
Contempt number 1. Appearing for the contempt number.
Wait. You are appearing for the applicant?
Yes, my lord.
Yes, where is the content? You are representing whom? Plaintiff. Originally plaintiff in the plain. Tenant.
Tenant.
Tenant. Now the appeal was preferred FMAT 256 of 2019 by the defendant landlord. By the defendant landlord, and order was passed by the division bench. Now by the coordinate bench. Now where is the contempt? You are representing whom? Yes.
What happened, my lord?
You are representing state.
No, my
my
lord.
lord,
Where is
he
the
is
state?
the-
No, my lord.
he is
Ajit
the
Kumar
landlord.
Sarkar. Contempt number 1.
Who
Mr.
is he?
Somelangiri. Mr. Somel, contempt number 1.
He is the landlord, appellant.
He is the
He is the landlord.
Then where is the contempt?
Here's the- What happened, my lord? Mr. Gautam Chakraborty is the arguing counsel, my lord. He is seriously ill. He will
Last occasion nobody appeared.
Yes, my lord. That
Matter was
on
called
that-
on 30th January 2026 when no one appeared. And it's not a regular bench, Mr. Rai. Every day it is not possible for this court to adjourn the matter. You have to do the matter today.
Yes, my lord,
Because
only give some time, my lord.
both of us are in different benches and both the benches are busy benches. It's not possible for us to assemble and take up your matter on a different day.
Lord, I know, my lord.
Sorry. And this matter was taken up on 30th January 2026 when no one appeared. This matter could have been dismissed
At
for
that
default.
point of time, he is serious. He was admitted in hospital. That's why, my lord, I am also.
Don't
in there.
embarrass this court, please.
That's why, my lord.
Don't
there is not-
embarrass this court.
Give some
Had
time,
it
my
been
lord.
had it been a regular bench, question would have been different. It's not a regular bench. It's very difficult to assemble.
Yes, my lord. I
Yes.
understand, my lord.
So it is very difficult to sit together without or leaving aside regular work of the regular bench.
I'm praying only
And you
2 weeks
know
time.
that what is my present determination. It's not possible for this court or the court where my brother is sitting to again sit together,
Yes, my lord.
leaving aside regular work of the regular bench. And not only this matter was taken up for consideration on 30th January when she appeared, I remember.
Yes, my lord. Yes, my lord.
She appeared, but no one appeared on behalf of you. Satisfy this court. Please don't embarrass this court. This court is not disputing that the counsel is unwell, but that does not mean that every day we have to sit together. You satisfy that. Where is the contempt?
My lord, the contempt, my lord, is your lordship's the division bench order, where is specifically recorded that the tenant portion kept in intact, and the promoter or the landlord can.
No, section 411 claims and notice was not interfered with.
Yes, my lord. The 411 does not, my lord, come in the force, my lord. The corporation has doing nothing in this matter. The landlord, at the instance of the promoter, with the help of the hooligans, demolished my roof. But
because there is a notice of the corporation. Corporation will not repair the premises. Premises is to be repaired by the owner of the premises.
Yes, my lord. My
Now
tenanted
please come to
portion.
the relevant part of the order.
Yes, my lord.
Come to page 27 of the contempt application.
Yes, my lord. I'm reading, my lord.
While we permit the appellant read it, last 4 or 5 lines at page 27.
Permit the appellant to stay. When the appellant, it should be tenant, my lord. The appellant to stay.
We permit the appellant. It should be tenant.
Yes, my lord. To
Very well.
stay.
Appellant is also staying there.
Stay.
Appellant is also staying there. Your client is staying there.
No, my
No,
lord.
no.
He is no.
Very
He is
well.
a fully tenant.
We permit the tenant to
stay in the premises without changing the nature and character of the suit property as permitted by the trial judge. We make it clear that this order should not be construed to be interpreted as a bar upon the KMC to exercise its power. That is the point where they have not exercised their power. The landlord on its
Where
own.
is the willful deliberate violation?
But the landlord demolished, my lord. Your lordships, the division bench permit me.
Try to appreciate the predicament of this court. We are only considering the contempt application in contempt jurisdiction, in a special jurisdiction. Now, unless there is a willful, deliberate, contumacious violation, court cannot entertain your application.
The landlord.
There is a specific direction that the 411(1) notice will not be given effect to.
But that they have not exercised that. The corporation has not proceeded with regarding that notice. Only the landlord.
What corporation will do? Find out, show me 411, you will get the answer there. It's not a mere demolition notice.
You know, the
When the
trial
house,
notice
when
also
the premises is dilapidated or is found to be uninhabitable, in that event, this notice is issued for demolition or repairing
yes,
of the premises in question. So therefore, in contempt, this issue cannot be gone into.
in the name of Milord, in the name of repairing, renovation, he has
Are
demolished.
you aware
here,
of 411 provision?
but on the basis of 411.
Show me 411 provision. I will make it clear to you.
That's why, Milord, I praying, Milord, only give 7
Not
days
a regular bench, Mr. Rai.
Milord, give.
Sorry, had it been a regular bench, I could have adjourned the matter and fixed it up after
Because of
15 days.
Milord,
It's not
senior is
possible.
arguing, Milord. He is all through arguing this matter. Milord,
Maybe,
from trial court.
maybe he.
That's why-
We are very sorry to hear that he is not well, but it is not possible for us to see
Only one chance,
because there are no other matters before this court. Only for these two matters we are sitting today.
Well,
And
only-
not only that, this is not the first time this matter is being taken up. Previously, matter was taken up. Nobody appeared on behalf of the applicant. Matter was adjourned.
Milord, this is
Matter was
not-
adjourned. Sorry.
That last
Please
chance your
show
lordship
me
give me.
411 দেখাও তো কর্পোরেশন একটা আছে কলকাতা মিউনিসিপাল কর্পোরেশন অ্যাক্ট 1980
Milord, give me one chance, Milord.
না এখানে আমার ডিটারমিনেশন চেঞ্জ হয়ে গিয়ে এখানে পাবে
Let his Milord, let him come. Milord, give me one chance, Milord. On 7 days or Milord, or 15 days, Milord, 2 weeks time may be granted. The brief is also not with me, Milord. That is the difficulty also. Total brief is not with me, Milord.
You are the advocate on record.
Milord,
And
that's
brief is
no,
not with
Milord.
you.
Your lordship knows that I am just
Because I am part of another division bench which passed this order. You are the advocate on record and your brief is not with you.
only the contempt.
Here I am adjourning the matter for 7 days, pay a cost of rupees 70,000.
That's Milord, your lordship knows that, Milord. That is why my predicament also. But I am go there and meet with him that he is very he told me that only 2 weeks time.
পড়ে দেখুন
Right.
কোথায় contempt এটা। কোথায় willful deliberate violation?
You only show us where is the contemptuous act.
But the landlord, but I have made complaints, so many complaints regarding when is going on these things.
Making complaint is not.
Now you are representing all the alleged contemners.
The contempt application has not been served by me.
Is not the rule. Why you are appearing today? In contempt, there is no requirement to serve notice. If contempt is admitted and direction is passed to serve notice, in that event you can. Otherwise not. It is not necessary to serve. Action. No, it is not a demolition of unauthorized construction. If the building is dilapidated,
multi-story building has been constructed, throwing me out.
you
That
could
is
have preferred appeal against this order.
Yes, my lord. That's that some
Because
protection is there.
411 was not, notice was not interfered with. You come to this, apply your mind, Mr. Rai.
The last
You-
paragraph
you
submission of
come
Mr.
to page 27.
Well,
You
28.
come to page 27 of the contempt application again.
My lord. The
Yes,
page-
yes, read it.
Page 28, my lord. Mr.
Come to
Chok-
page 27, please read it. While we permit the appellant to stay the premises, to stay in the premises, read it.
Yes, my lord. To stay in the premises without changing the nature and character of the suit property as permitted by the trial judge, we make it clear that this order should not be construed to be interpreted as a bar upon the KMC to exercise its power under section 411(1) of the KMC Act in accordance with law. The notice under section 411(1) is not under challenge.
Then what remains?
My lord, thereafter, my lord,
And
Mr. Chakraborty.
let us see 411.
My lord, thereafter, my
Let
lord,
us see
My submission
Yes, yes,
recorded
yes,
and
read it.
Mr. Chakraborty, learned advocate appearing on behalf of the respondent, has submitted that the KMC may not take any steps without informing the respondent, and respondent shall be at liberty to challenge the action of the KMC if situation so demands. It is not desirable to us to
Dwell
on the said issue, as we have not been invited to decide the question as to whether KMC was justified in issuing the notice under section 411 of the KMC Act. Accordingly, we do not wish to make any comments.
There was submission made on behalf of the respondent plaintiff was not accepted. Was not accepted.
Yes, my lord, but the
It is not a contempt at the instance of the appellant. It is contempt at the instance of the respondent. Now, if you come to page 28 and read the second paragraph after the running paragraph, you will find that the learned advocate appearing on behalf of the respondent had submitted that the KMC may not take any step without informing the respondent, and respondent will be at liberty to challenge the action of the KMC if situation so demands. Then the finding is returned by the coordinate bench. What was the finding? With regard to the submission made on behalf of the plaintiff respondent, that it is not desirable to us to dwell on the said issue, as we have not been invited to decide the question as to whether KMC was justified in issuing the notice under section 411(1) of KMC Act. Accordingly, we do not wish to make any comment on the said notice. So your submission made on behalf of the plaintiff respondent was not accepted.
But the situation, but the things is, but the
Now come to section 411.
The owner, admittedly, my lord, constructing the multi-storied building by throwing out me. But
yes, read it. Read it 411 at the bottom of this page. Mr. Raghi. It is not a demolition. Please read it. Please read it. 411. Read it. Let us understand the law or the legal provision.
If any wall or building or anything affixed thereto be deemed by the municipal commissioner to be in a ruinous state or
ruinous
state or likely to fall or to be in any way dangerous, he shall forthwith cause a written notice to be served on the owner and to be put on some conspicuous part of the wall or building or served on the occupiers. Well, here my contention is no notice has been served to the tenant.
You are not to be served with notice. You are the tenant.
But the occupier.
Yes.
Occupier, my lord, your lordship's
and it was not decided. Today we will not permit you to open the case.
No, I am not.
We are hearing the contempt.
But my right has.
We are hearing the contempt. We are not permitted to open the case today.
But my right is well protected by the civil code. On that order, appeal was preferred by the landlord. In that proceedings, but this was recorded. There was a clear injunction.
You show me where is the contempt? Where is the violation of the order of this code?
Well, this is the violation that they demolished, and my portion, only 49 square feet portion, that has been thrown out, and remaining portion that has been vacated.
That is permissible since 411 was not interfered with by the petition by the coordinate bench.
By this way, the civil court's injunction order has been violated. My right has been protected in the civil court.
We are not hearing the matter on merit.
But that's why I'm praying, my lord. I beseech your lordship, kindly give.
We are hearing the contempt petition. We are not hearing the matter on merit.
Well, that's why I.
So therefore, you don't make this submission. You have to demonstrate before this court that the order passed by the coordinate bench on 23rd September 2019 is violated.
Lord,
to what extent violation is there? Show me.
That the picture has been annexed, my lord. Everything has been annexed.
Sorry, don't show us the picture. We are not hearing on merit.
That's why,
you show me that where is the violation.
Well, that's why I'm praying, my lord. I will not satisfy your lordship.
No,
Due to the all papers
no
with not
time
me.
can be granted every day. It's not a regular
Whether
bench.
the
We have to
appeal-
appreciate our difficulty.
Every all papers lying with that senior my lord. That's why give me 2 weeks time. Thereafter, your lordships pass the order. 2 weeks or 4 weeks as your lordships.
কি করবেন বলুন?
Give me as a last chance, my lord. I pray in the Lord.
If at the time of call, learned advocate representing the applicant. No, get it out. At the time of call, on behalf of the applicant, accommodation is paid for since the learned advocate is unwell. Stop. Hearing of this contempt application is adjourned. Stop. List the matter under the same heading for further consideration on কবে রাখবো বলুন? 6 তারিখ 27 তারিখ রাখবো 27 আপনার 3টে রাখবো on 27th is কি বললাম is adjourned till 27th March. No, hearing is adjourned. Stop. List the matter under the same heading on 27th March 2026. Stop. However, it is made clear that no further adjournment shall be granted on the next date.
Well, I'm grateful. And excuse me, Lord.
Huh?